25 CR 1212. I'll take appearances. Ms. Raines.
Morning, Your Honor. Katie Raines on behalf of the people.
Thank you. And sir, if you'd say your full name, please.
I am the living, breathing man, Austin James Wright, Jr.
Mr. Wright, I will consider that you have entered your appearance. I will say that I acknowledge your non-conventional entry each time requested. I don't know if that's an attempt to lodge an attempt at a sovereign citizen entry to suggest that the court does not have jurisdiction over you. I will simply let you know if at any time I'm not aware of whether or not Austin Wright is present, I will have to issue a warrant for his arrest. I acknowledge your appearance, Mr. Wright. You have entered that appearance. There is no need for such a warrant this morning. Good morning to you and Ms. Raines. We're set for motions, and the reason the court set this motions, and it was an additional motion setting because the court wanted to make very clear to Mr. Wright that we were set for this motions and that the court wanted to clarify any motions filing deadline and the court's deadline for any plea cutoff. I acknowledge Mr. Wright's previous filing as it relates Mr. Wright, you filed a motion on August 4, 2025, and the court previously ruled on that. I acknowledge it just once again because the court recognizes that there have not been additional filings since then. The court recognizes the motion is based on a concept of corpus delicti. The court's already ruled, and Ms. Raines, let me look to you and ask you just to bring me up to speed on status, and I'll give Mr. Wright the same opportunity.
Yes, Your Honor. An offer has been extended. I can make a law for record. My understanding is that Mr. Wright does not wish to accept the plea offer and wishes to have a jury trial.
Mr. Wright, is that your understanding? Is that what you don't want to accept the offer and you want to go to trial? It is your right. I'm just making sure to clarify.
Before we even press play, let's set the stage, because this case is a masterclass in how confidence, misinformation, and stubborn ideology collide with the cold reality of the courtroom. What you're about to see is part one of a two-part saga involving a self-described, sovereign citizen grandpa, who makes a decision that will likely haunt him for the rest of his life. He's facing 8 criminal charges, 2 serious felonies, and the prosecution puts a plea deal on the table that most defendants would jump at without hesitation. Reduced exposure. Fewer consequences. A clear off-ramp, but instead of taking that deal, this defendant decides he knows the law better than the judge, better than the prosecutor, and better than decades of precedent. He leans fully into sovereign citizen talking points, jurisdiction challenges, semantic word games, and the infamous, living breathing man, routine. And here's the twist, this isn't even the trial yet. This is just the pre-trial hearing where he manages to irritate the court, undermine his own position, and set himself up for
questions you wish to ask Ms. Raines or the court.
Questions I'd like to ask her.
All right.
On the record.
Well, I can't be part of your negotiations with.
It's not a negotiation.
Help me understand, for example, what
I'm
you're
just trying to.
Mr. Wright, hold on. We're going to talk one at a time. And so help me understand the nature of the questions you'd like to ask Ms. Raines.
The nature and cause of this action.
Mr. Wright, have you received the discovery in this case? Those are the police reports.
Some of them I still have. I was called yesterday that there's more discovery that I have to pick up.
All right.
Today.
Ms. Raines, any record on Mr. Wright's obtaining the discovery in this case?
I actually don't have a note from our discovery department about whether he did pick up the initial batch. I can tell the court there are, I think, two new documents. One is a CV for a crime scene analyst who fired a weapon, and another is a criminal history for the traffic victim in the case. The rest of the reports should have been available to him, and so if he did pick up initial discovery, he should have all of those initial police reports.
All right. So, Mr. Wright, I'll let you speak with Ms. Raines. I'm not going to facilitate a discussion. I've given you an opportunity to file motions for me to entertain today. What I'm going...
I filed a motion, sir, and
right here, we get our first clear signal that this hearing is about to go off the rails. The phrase, living breathing man, isn't just quirky language, it's a deliberate sovereign citizen tactic. The idea is to separate the flesh and blood person from the legal identity named in the charging documents, hoping that by refusing to be Austin Wright in the legal sense, the court somehow loses jurisdiction. Spoiler alert, it never works. Judges hear this then legally, the judge has no choice but to issue a warrant. This instantly strips the sovereign citizen argument of its imagined power. You can call yourself whatever you want philosophically, but the court deals in legal realities, not wordplay. And from here on out, every time the defendant tries to dodge accountability with semantics, the
parties in this room to the outcome or the process in this courtroom.
Mr. Wright, your motion that you filed implicating corpus delicti, which I read to be pertaining to your challenge of facts and circumstances constituting an alleged breach of law, I recognize that the matter was bound over from county court to district court on June 18, 2025. In light of the charges, I don't see that you had an opportunity for a preliminary hearing. The court does not have to go through a probable cause determination other than what's afforded by law. And when there's an opportunity for a preliminary hearing, your motion I read to be one in which there is challenge of probable cause. I previously denied that request based on your plea of not guilty, your challenge that there's insufficient law.
Look, I didn't plead not guilty.
Mr. Wright?
You entered that plea for me.
Mr. Wright, you're interrupting me, sir.
From the bench.
Mr. Wright, you interrupted me and I'm going to finish talking. First of all, you asked me why I had not given you a hearing on that motion. That motion I ruled on. I don't find anything further that requires a presentation of evidence or further hearing. I gave you until November 12 to file any additional motions. None were filed. Today we're set for that motions hearing. Mr. Wright, I've given you that opportunity. As far as your not guilty plea, I'm not going to cause delay waiting on you to enter yourself a plea of not guilty. So I entered it on your behalf, which is the option preserving your constitutional rights if you do not enter a plea.
This is the moment where alarm bells should be blaring for any rational defendant. The prosecution confirms that a plea offer is on the table, and based on the context, this deal appears to significantly reduce the defendant's exposure, potentially dropping felony charges in exchange for a misdemeanor resolution. That's not speculation, that's standard prosecutorial practice, especially when trial risks are high. But here's the problem: sovereign citizen ideology convinces people that plea deals are traps, that courts lack authority, and record reflects that the defendant rejected it. That matters later. Because if this goes badly, and it almost certainly will, the defendant won't be able to claim he didn't understand what was at
trial in which we are going to try the facts. Now, Mr. Wright, I'm going to give Ms. Raines an opportunity to explain what the plea offer is. And Ms. Raines, if as part of the Lafler-Frye you wish to go through the present 8 charges in which the court has entered a plea of not guilty on behalf of Mr. Wright, discussing what the possible penalties are, the court would accept that as part of the record. Mr. Wright, do you have something to write with?
Yes.
All right. If you wish to take notes of this, I'm going to ask if you've heard, understood this. This is giving some context of whether or not you understand there was a plea offer, possible consequences, and if you wish to then not accept that offer, which you do not have to take, and you certainly do have a right to a trial, including a jury
I
trial.
don't accept the offer.
I understand. That is very clear, but I need to make sure as part of the record what the offer is because I don't know what it is, and we're going to make a record for your benefit what that offer is that
Right.
you're declining.
So this is a court of record.
Ms. Raines.
Yes, Your Honor. I will go through the original 8 charges first. As to both counts 1 and 2, they are both Class 5 felonies. They carry the possibility of up to 1 to 3 years in the Department of Corrections. They are also probation-eligible offenses. Count 3 is a traffic 2 offense that carries a possibility of jail from 10 to 90 days or a fine of $150 to $300 or both. Driving under the restraint is a traffic infraction A. It carries a possibility of a fine between $15 and $100. Count 5 is a traffic infraction B that carries the same possible penalty as count 4. Count 6 is also a traffic infraction B, so same possible penalties as the 2 previous there. No insurance is also it's a traffic 1, so it carries a possibility of jail from 10 days to 1 year or a fine of $300 to $1,000 or both fine and imprisonment. And count 8 is a traffic infraction A, which again carries a fine of no less than $15 but up to $100. The plea offer that was extended to Mr. Wright in this case contained 2 charges that he would have pled guilty to. One was a defective vehicle, which was a traffic infraction A, so a fine of between $15 and $100, as well as a plea to a misdemeanor 1, possession of an illegal weapon, which carries the possibility of up to 364 days in jail or up to a $1,000 fine or both. That plea would have required Mr. Wright to forfeit the weapons that law enforcement discussed.
This exchange perfectly captures the sovereign citizen paradox, endless questions that never actually seek answers. When the defendant says he has a bunch of things he's pondering, the court immediately tries to narrow the scope. Are these legal questions, personal confusion, or negotiation attempts? And instead of engaging directly, the defendant drifts into abstract concepts like nature and cause of the action. That phrase sounds sophisticated, but it's functionally meaningless in this context. Courts deal in charges, evidence, and procedure, all of which are already laid out in discovery. This is why the judge keeps redirecting him.
Mr. Wright, were you able to hear and understand Ms. Raines' statement of the charges, the possible penalties if you were convicted, and the plea offer?
I comprehend what she said.
All right. And Mr. Wright, I think you have made it very clear to me, but I wanted to make sure that you understood that. Is this plea offer to plead to a traffic A with a fine of $15 to $100 and a class 1 misdemeanor possession of an illegal weapon with an agreement that you would forfeit the weapon and no objection to probation? Is that something that you do not wish to enter into and that you wish to rather proceed to trial on all counts 1 through 8?
I want to first know who the injured party is.
Mr. Wright, let me ask you this. Do you want to enter into this plea agreement or decline it and go to trial? Do you want to go to trial and not enter into that plea agreement? Because you answered yes, but I didn't know what you were answering yes to. I'm giving you a chance to clarify.
I do not want to enter into the plea agreement. There could be financial interest in the process of this court, of each of the individuals in this court.
Mr. Wright,
That's a conflict of interest.
Mr. Wright, anything else, sir?
No. Does the prosecutor make any verified claim under penalty of perjury?
So to the extent that there was any request under Rule 97, the court does not self-recuse. The court does not recuse based on the oral request, suggesting that the court has any personal interest in the outcome of this matter. It does not. The court has no association with the parties or the outcome of this matter other than that of one of a professional association as disclosed in these proceedings. We currently are set for trial to begin January 14. It's a 3-day trial with all times beginning at 8 o'clock. Mr. Wright, I'll give you the same courtesy and opportunity, but I'll ask Ms. Raines first. Ms. Raines, anything further for the record on behalf of the people?
No, thank you.
Mr. Wright, there are certain things that you are saying that I don't fully understand. It may be that you have some questions of Ms. Raines that you may wish to discuss in person by way of email or otherwise. Mr. Wright, anything further, sir?
Discovery is where ideology meets evidence, and evidence always wins. The prosecutor calmly lays out what's been provided: police reports, expert credentials, criminal history, and additional documents that are already available for pickup. There's no mystery here, no hidden conspiracy. Just paperwork, timelines, and facts. That what's telling is the defendant's vague response: some of